The appointed time. So I would chair the meeting for the moment. We've got the quorum, 3 people, and it's the appointed time. First of all, we'd like to elect the chairman. I have the highest president, so I'm here to chair this session on election of the chairman. Nominations? Any nominations for the chairman? Dr. Kwok Ka-ki. Any other nominations? Seconder, any other nominations? No. Then that's good. Dr. Kwok Ka-ki elected as a chairman, so I'll hand over the chair to Dr. Kwok. All right. Is there a need to elect a deputy chairman on this bill? Yes or no? No. So then perhaps we'll invite the administration team in. I believe that we will not spend too much time on this bill. Earlier on, I submitted an application because of some technical reasons. Perhaps my name has not been included. Yes, the Secretariat? Yes. Mr. Chen, your name has already been included, right? So let's accept the application from Mr. Chen to join the committee. Any objection? If no, then that be it. Welcome the administration team. I will not read out your names one by one. You've got the papers with you, papers from the administration and also the papers from the legal advisor. Perhaps I would hand over the floor to the administration to brief us on the amendment, and then the legal advisor can also raise his or her views. Who to take us through the paper? Well, I'll be brief on the proposed amendments. Right now, the Section 15.3 of the Human Reproductive Technology Ordinance prohibits the use of RT procedures to select the sex of babies, except for avoiding the birth of a child suffering from a serious sex-linked genetic disease. And so such diseases are included in Schedule 2 to the ordinance. And also such a procedure has to be supported in writing by 2 medical practitioners. The spirit behind is that without medical grounds, the RC procedure should not be carried out to select the sex of the babies. In recent years, we've seen that there has been an increase in local press advertisements promoting sex selection services available in other countries. And also some intermediaries locally have also distributed certain promotional leaflets. And 16.2 and 17.2 of the present ordinance also prohibit commercial dealings of gametes, embryos, and commercial surrogacy arrangements, respectively. And they also prohibit advertisements relating to these arrangements. But then the ordinance does not contain similar provisions to prohibit advertisement on sex selection services through RT procedures. For the overall well-being of the society, for example, to upset the sex ratio in the population, we do see a need to amend the law in this regard. The scope of the prohibition will cover all media, including the Internet. we've also provided certain information on the provisions to the legal advisor. So perhaps I'll pause here. Thank you, Mr. Chung. The legal advisor, if you look at CB bracket 2188/1415 bracket 02, well, the legal advice has been very good in asking altogether 10 questions, and the administration has already made a reply. And on the 19th of March, the administration has given us a reply in response to those 10 questions. Perhaps the legal advisor can take us through your questions, and then before the administration answers, I'll open the floor to members for questions. Thank you, Chairman. Sorry, you haven't switched on the mic. Can you hear me? Please speak closer to the mic. The members would notice that the amendment targets not only at the advertisers but also the web page hosts and internet operators. The members can note 2 points. First of all, in relation to activities on the internet, should there be an express provision in the ordinance that under what circumstances will internet activities be subject to the bill? Should it be limited to the uploading activity or the location of the server, or is it just that the web page can be viewed from Hong Kong, that is under the scope of the ordinance? Also, should we provide a defense provision? Because the amendment also targets the publishers. Say if a certain employees in the publisher is responsible for page making and typesetting, and they are also responsible for distributing the advertisements, so to speak. If there is no defense provision, then they will be inadvertently caught in the law. So there are some other questions related to the drafting, so members can make reference to my questions. I'll open the floor to questions by members. The first, Dr. Helena Wong, 5 minutes each. Perhaps I'll read out the names: Dr. Helena Wong, Raymond Chan, and Mr. Charles Mock, and also Ms. Sid Ho. Are we regulating only advertisements published locally, or advertisements published overseas or in the mainland, but then the services are provided in Hong Kong? Can we deal only with those? If advertisements are placed in the mainland or having promotion leaflets distributed on the mainland in the mailboxes there, and then the advertisements say that they can carry a bottle of blood to Hong Kong to see whether what the sex of the baby is. Well, should that kind of scenario be subject to regulation under the ordinance? Will the ordinance regulate activities outside of Hong Kong? Well, we are not just binding ourselves to looking at advertisements in Hong Kong. The spirit behind is that we want to prohibit such advertisements in Hong Kong. As regards whether we can also cover overseas cases, well, it depends on the evidence we can collect. I can't say for sure at this moment. The provisions as they are drafted are not limited or confined to local advertisements. Dr. Wang mentioned about carrying a bottle of blood to Hong Kong and do tests here. That kind of scenario is not under the scope of this ordinance. This ordinance is about RT procedures like test tube babies, services like those. That has nothing to do with the present ordinance. You are talking about sex selection of babies. We've heard many cases that blood is being transported over the border to Hong Kong for testing. And through such blood testing, we'll be able to ascertain the sex of the babies. And actually recently, the customs have identified such cases. How come that these cases are not related to the ordinance? You mentioned that the provisions are not confined to where the advertisements are placed. if there are reports made to you and then you have collected enough evidence, and the promotion of leaflet is collected in a village, say in Shenzhen, can you enforce the law in that case? Well, there are cases where hyperlinks are provided, and the hyperlinks link to a web page on the mainland. Dr. Choi, let me explain first that this ordinance has to do with RT procedures, and through such procedures, we are selecting the sex of the babies. The ordinance also provides definitions of RT procedures. While we are talking about IVF services and also production of an embryo outside the body of a woman, and then after the egg is fertilized, put the embryo back to the body of a woman. So that doesn't include what Dr. Helen Wang has referred to. And, well, in the case of a woman who is already got pregnant and the blood is extracted from the embryo, and then there is blood testing, and that the sex selection is done after the woman has got pregnant, it's not before. So that doesn't fall within the scope of this ordinance. Do you have any other ordinance regulating that kind of situation? The media journalists have asked similar questions before, and that those cases involve blood being transported into Hong Kong, and the blood is then being tested in a local lab to ascertain the sex of a baby. Under existing laws in Hong Kong, that kind of scenario doesn't fall within the scope of our present ordinance. That is subject to other ordinances in Hong Kong. And those ordinances have to do with laboratory technicians, which are under some other kinds of legislation in Hong Kong, and also the registration of medical practitioners in Hong Kong. And also, when we suspect that the blood is infectious, then the blood must come with a permit before it can be transported into Hong Kong. So that kind of situation falls under the scope of these several ordinances and not under our present ordinance. So that I would like to make clear to Dr. Wang. That shouldn't be the subject of our discussion today. Chairman? Can we ask Dr. Choi, Dr. Sarah Choi, to submit information on the ordinances that she mentioned, i.e. ordinances which governed sex selection of babies. What are the existing ordinances in Hong Kong? We would like to make sure that there is enough protection provided by other ordinances. In that case, we don't have to build that element into the present ordinance. With that, we can supply a paper to the member afterwards. Mr. Chen, the scope of the amendment is rather narrow. It has to do with prohibiting advertisements, promoting sex selection of babies. I think we should take this opportunity to review the entire HRTO. I have expressed to the Steering Committee on Population Policy, the SRG is encouraging childbirth in Hong Kong. So should we be doing a review on the HRTO as a whole? I hope to have further exchanges with the government on that. Before we discuss further, I would like to seek some basic information. The first question is the enforcement situation of this ordinance, HRTO. You can focus on the enforcement actions on sex selection. After the ordinance came into force, how was the enforcement like? Who was responsible for enforcement? How is monitoring done? Is there any reports of irregularities and so on? What about the prosecution situation? Do you do regular visits or patrols? Do you do undercover operations? Do you act upon receipt of reports or what? The ordinance is there prohibiting sex selection. But then when sex selection does happen, can you really enforce law? If this is happening in a lab, how can you catch the people involved?
What
about prosecution, conviction, and penalty? If there is no detail given today, I hope it will be given next time. As far as I know, the ordinance is mostly handled by the Council of Human Technology. So, what about this council? What is this composition? What about the operation, this Council on Human Reproductive Technology? I've also heard complaints from the sector that this is a black box operation. And I think we should give the opportunity for stakeholders to come to have their say. I know that when it comes to reproductive practitioners, they have a lot of questions. Say, for example, any such experts on reproduction, human reproduction, any experts on embryos in the council? Who is to take this question? Well, in relation to the composition of the council, there is one chairman, one deputy chairman, 4 practitioners in ob-gyn, 1 social worker, 2 people with legal qualification, and 2 with religious background or people who teach religion, and 1 teach theology or humanity, 1 psychologist, 1 registered nurse, 1 sociologist, and 4 government representatives, including 1 nominated by the Secretary for FHB, 1 nominated by the D of H, and 1 nominated by the HAB, and 1 nominated by the Social Welfare Department, and no less than 8 other members. Any experts of human reproduction or embryos? Well, of the 4 ob-gyn doctors, well, what about currently? Of the 4 members, none of them are experts in embryo medicine. But what about appointment? Appointment is by the chief executive. What about prosecution? Any numbers? When the council receives a complaint, we will conduct a preliminary investigation to see if there is a prima facie case, and if there is a contravention of the ordinance, say for example, sex selection service that is not related and that is not supported by medical grounds, we will conduct investigation assisted by the FHB and the D of H. So you take a passive role. What about taking the initiative to carry out an investigation? When it comes to a sex selection service, if it's based on medical grounds, it is lawful, but the council will have to vet the case. Well, I'm talking about illegal cases. Well, when it comes to those, we act on complaints. Any numbers of complaints? No. No complaint has been received and no prosecution initiated. I think in the end at the end of this meeting, we'll discuss whether we need to hold a public hearing, Mr. Chan. Next, Mr. Charles Mock. First, about human reproductive technology, HRT. There is a prohibition on sex selection service. I don't have a strong view at this stage, but my concern is also related to the questions raised by the legal advisor. is about dissemination of information on the internet. Well, first of all, it's very interesting the way you explain this this bill. You cover all media, and you single out the internet and mention it in particular. And I think you think that a lot of the problems come from the internet. And I see that in recent legislations, it may not have anything to do with the internet. That is the main matter. I've had discussions with the administration on this. I see that in the legislations formulated recently, there has been regulation on the internet or duty imposed on operators of the internet. As the legal advisor mentioned in her questions, in a lot of the circumstances, it's very difficult for you to enforce the law, and this is not technology neutral, and very often is outdated. And you still talk about whether the server is located in Hong Kong. It is completely meaningless because we have cloud computing. Once something is uploaded, you have no idea where the server is, whether it's done in Hong Kong or overseas. So I think your answer is quite outdated. And the way it's drafted is different, so there is inconsistency. Whether it's a remote payment gateway or this HRT or any other legislation, it's something that is completely different. But it all came back to the regulation of the internet with a different practice. Perhaps it's because it's a different person who drafted it, and some will be more heavy-handed than others. Is it because of the regulation itself, the subject matter that is different? That's why there is a different practice. But it confuses people because they don't know what to do, whether it is ISP or operators. And if you impose a regulation on the internet on every single thing, it will be a preemptive of regulation of the internet itself. Well, perhaps it started off as something innocent and harmless, but the more it goes towards this direction, in the end, there will be regulation of every single thing on the internet. And I think this is a very good basis for us to start with. And I have a lot more questions. I will deal with them one by one. The first one is about publish and distribute. That is in relation to the questions raised by the legal advisor. I don't think you have given the answers yet. Have you given the answers yet? The legal advisor would like you to give the answers before the meeting. They have been given. Well, in relation to question 1, that is using overseas servers to upload or distribute for the act to be conducted outside Hong Kong. Well, perhaps it may be uploaded overseas and it can be seen in Hong Kong, or a Hong Konger uploads the information to an overseas website. But I don't know where the server is. Maybe there is a cache or there is a cloud computing involved. Well, I've used up my time. I will continue in the next round. But can you at least give me a simple answer? Well, there aren't many people in the queue. Perhaps I'll give you some background information about the internet. In the past few years, when it comes to the complaints we've received or advertisements, it started off with the press. We have consulted the council. We have also consulted the local medical profession and some other consultation in the middle of last year. We've received general support, but we've been reminded at the same time that when it comes to the media, it doesn't just cover magazines and newspapers. We're reminded that there is also the internet as well. We hope that we want to cover advertisements placed on the internet as well. That's our preliminary idea. The legal advisor sent us 2 letters, and I apologize that we complete the answer to the second letter late yesterday. I don't know whether the answer has been distributed to you. Perhaps, if you wish, Chairman, I will defer to the legal the DOJ to explain to you the second batch of answers. We've received the first batch. We've just received the second batch. Can you maybe quickly go through the answer you gave yesterday? Perhaps it should be distributed to us first. I think the number is bracket 05 1188/1415 bracket 05. It was sent urgent by fax. Perhaps some of you haven't received it yet. Mr. Look. I thank Mr. Mo for his questions. In relation to question 1, I will take you through the answer. The question was content uploaded from overseas servers, whether it is under the jurisdiction in Hong Kong. You see that, well, first of all, the provisions do not mention about uploading. If the act is committed in Hong Kong, then it's under the jurisdiction of Hong Kong. And as to whether there is sufficient evidence to show that the act took place in Hong Kong, when it comes to distribution, actually this constitutes distribution in Hong Kong. Well, but as long as you open a window on the internet, then you will be able to see it. So everything is distributed in Hong Kong. So even if you don't use the hyperlink, you open a web page, then you have access to everything in the internet. Take it to the extreme. The legal advisor also mentioned it. Say on Facebook, I said, if you're interested, please read on. And then there is a hyperlink to somewhere overseas, whether it's mainland or Thailand. It's a web page. So according to you, that message on Facebook is a crime. Let me explain that, that is to meet the requirement of distribution. When we draft the provisions, we have also included other elements, say for example, the mental element, and whether there is distribution, whether there is advertisement. They all have to be met before enforcement action can be taken in Hong Kong. I think you have to wait for the second round. I don't think he has answered you. Yes, because I would like the administration to give me an exhaustive list of all the elements. Miss Sit Ho? Well, I just got on the internet. I typed sex selection and a lot of the websites pop up. Some are in Hong Kong, some It said that, sex selection guarantee in California, US, and there is one that says it's non-intermediary and it's very expedient. And then there is also one that says that you can do it in Thailand, 30,000, 50,000.
Legal.
If the bill is enacted, say, well, if we go to Google search, I mean, is that being regulated under the ordinance? Chairman, I originally did not plan to ask this question, but after having heard Mr. Mok's question, I believe that we generally support that there should not be sex selection from RT procedure, and the amendment has to do with prohibiting advertisements and even including those on the internet. We are worried that there may be problems in enforcement, and I'm worried that you will overdo it and you will be curbing freedom of speech on the internet. So I think it's just right that Mr. Mok joined this Bills Committee. Chairman, I have several questions. I will ask them one by one. First, after the bill is enacted, what about the Google search and other search engines which provide information on websites all over the world? Are these search engines breaking the law? You have to consider that carefully. If we want to cover search engines in our ordinance, you would be doing something very similar to the Green Dam proposed by the mainland a couple of years ago. And also, so you have to be very careful. Secondly, about surrogate mother. The ordinance also covers overseas jurisdictions, but, well, very often it's difficult to enforce a law overseas. Well, 2 to 3 years ago, a rich man in Hong Kong was having several babies overseas, and he was very frank in saying that a surrogate mother was employed in the United States. And he was saying that several surrogate mothers were involved. We criticized the government very seriously at that time, and we doubted whether it's because this man was a rich man and you dared not enforce the law outside of Hong Kong. And then the secretary afterwards said that he would follow up on the case. In the U.S., such acts are lawful. So how are you going to coordinate with the U.S. authorities on such cases? What's the progress of an investigation on that particular case? I don't see any prosecution taken yet. Now you are discussing about advertisements on internet, search engines. How are you going to enforce law in the future? Would you also cover search engine companies as well? Mr. Chung? The provisions contain the word knowingly, so there is a motive behind. So we will not be casually enforcing the law. There is no question or no problem with that at all. As for the effectiveness of law enforcement, for overseas jurisdictions, it is difficult to collect evidence for cases overseas. When we drafted the amendment provisions, we didn't want to confine ourselves to enforcing the law locally. different companies may try to use the internet as a media to circumvent the law. And our amendment covers overseas jurisdictions, and that serves as a starting point, and we try to collect evidence if there is a case to be investigated into. And if needed, we would also take our prosecution. He hasn't answered Ms. Sitho's 2 questions. The first question is on Google search. Well, her question has been clear. Would you cover that as well? Second, surrogate mothers hired by rich men in Hong Kong. Have you enforced the law? Have you conducted investigation at all? We try not to discuss it in too high a profile manner in the entertainment pages of newspapers. I've referred to the term knowingly. In enforcing the law, we would take consideration of that word, knowingly. We would not be casually enforcing the law, and our ultimate objective is to deter such advertisements. We don't want to see such advertisements. Chairman, well, if you want to legislate, but then you said that there are difficulties in enforcing the law, so you're not sincere in enforcing the law. So the piece of legislation is useless, and that will deal a blow to the rule of law in Hong Kong. If you drafted the legislation in a relaxed way and you are trying to enforce the law rigorously, then my question is, if there is a search engine having such advertisements and there is a complaint received, you should remove the advertisement. Mr. Charles Mok also mentioned that regulation of internet services is provided in many different pieces of legislation. Is there a consistent way of drafting so that the way it is drafted will not differ from one piece of legislation to another? Say for the copyright ordinance, there is a provision on the exemption for some publishers in certain cases. And for this particular ordinance on hand, you said that there would be a defense if the person is not doing it in a knowingly way. Does the DOJ has any consistent way of drafting the law, say for provisions like collecting evidence, searching premises, and so on? Is there a consistent way of drafting the law so that the enforcement can be taken consistently as well? Several members have asked a question related to the law, and the DOJ colleague must answer this. There are several different ordinances touching on internet. Is there a consistent way of drafting? Is there a consistent way of enforcing the law? If yes, then tell us which clause is consistent, and if not, why not? Well, we would have regard to the policy intention of the legislation and in drafting the legislation. So each case differs. Each piece of legislation differs. So that's why you have this skeleton provision in this law on dishonest use of computer, and you try to catch everyone by that provision. So next time, perhaps the DOJ colleague can provide us with a summary of your different ways of drafting the legislation or provisions on internet. You said that because different ordinances have different purposes, and you drafted the provisions in a different way as a result. If we try to open a floodgate here, then that may be very problematic. I think we don't hear different views on how RT procedure advertisements should be prohibited. But if you mentioned internet, then that's very worrying. So next time when you come back, please give us some information on the policy objective of covering internet, the way you will enforce the law, and also prosecution numbers, and so on. Second round, first member, Mr. Raymond Chan. I beg to differ from what you said about we having a general consensus on sex selection services. But anyway, I think we can further discuss about using RT procedure to select the sex of the babies. Now, say if I have 7 or 9 baby girls, well, how come that I'm not allowed to select the sex of my next baby? So that's something that can be further discussed. The DFJ colleague said that, well, the ordinance is there just to scare people. I asked about whether there have been any arrests or prosecutions in relation to sex selection services provided in Hong Kong. He said no. Then can you provide me with some information in writing later on? What about surrogate mothers? Enforcement of the law, prosecution, sentencing, and so on. Can you give me a record of any actions that you have undertaken? If there is none, no cases, then, well, the ordinance is just there to scare people. Now, if you don't mount undercover operations, it's difficult to catch people breaking the law. There's providing sex selection services illegally. Well, now you can't break into the lab to catch people. Then you are trying to resort to this amendment bill to prohibit advertisements. But so far I haven't heard how they are going to enforce the law. Will they be proactively browsing the internet, the websites to catch people? Or you will be playing only a passive role, and then you would also only act and investigate upon receipt of reports? So it seems that the ordinance is there to show to people that you're doing something, but actually you're not doing anything. In the case of the copyright ordinance, it's all right if we share the hyperlink which infringes on copyright. Even if I use the word recommended link, then I am not breaching the law too. It's only the people who actually put up the hyperlink who will be considered as violating the law. Now, just now, you said that if you just share this hyperlink, then you are all right. But if you add the word recommended or, well, this is some recommended hyperlink, then you may be in a problem. In the internet or in magazines, maybe I would just place an advertisement saying that this is a seminar on the latest RT procedure, and they are using sort of academic approach and saying that there is latest RT procedure available in the world, which is not available in Hong Kong. So people can be okay in that kind of situation. But then at the seminar, then the telephone number will be given to the participants, and then they can call up the telephone number to seek for further information. So, I mean, would that kind of situation come under the scope of this ordinance? I would like to respond to Mr. Chan's question on law enforcement. Under our proposal, we will act upon complaints. With regard to proactive investigations, well, you have to understand that there are many labs in Hong Kong. It will be very difficult to do patrols or visits, and then I think it will be more effective if we act on complaints. Under the HRTO, there is a licensing mechanism for labs which can provide such services. And for licensees, we do regular visits.
We send staff to conduct inspections to see that the laws has been complied with. Mr. Chan asked about statistics related to prosecution. We will supply the same after the meeting. Mr. Chan's question was, well, what if it's an academic seminar? The information was disseminated. There is a provision in the law. It says that it's purporting. It's in the provision. It says it's purporting. So in just common language, it looks like. Well, I don't know whether the answer given is useful to you. Mr. Chan was asking about an act that seems to be. So if it looks like it, then you can take action. Is that right? Let me try to answer you. Under the law, say in an academic discussion, it may not constitute an advertisement. What's under regulation is an advertisement. It says under the law that an advertisement is serves to promote something. If it's just a pure academic exchange, it may not constitute an advertisement. And Mr. Chen was talking about something in a part of a spectrum. If in an academic exchange there are salespersons to promote a certain service or product, then it may contravene the law. But if it's pure academic exchange without any elements of advertisement or promotion, then it won't fall under the scope of the law, because it only regulates advertisements. Speaking for the first time, Mr. Leung Ka-lau. I have questions on different areas, including ethics. First of all, I would like to get some information. Are there any countries that allow sex selection, that it is legal? That is only to seek information. And you also said something. Let me give you an example. There is someone who is not a Hong Konger, and in his country, this service is legal, and he runs the business. He puts an advertisement on the internet, which is for the world to see. And one day, this person passes through Hong Kong, and I complain against him. Does it mean that he has contravened Section 3A? That is Section 15 bracket 3A. And what about examination? Ultrasound to check the sex of the baby. Is it part of a sex selection service? Because I know that a lot of people on the mainland carry pregnant women's blood over to Hong Kong to check the sex of the baby. Once they know the result, well, I don't know what the result will be used. Perhaps it's with the intention to select sex. So, checking the sex of the of the baby or the embryo, is it part of the service? A similar question has been asked by Ms. Wong, and I think part of it has been answered. The first or the second question? The third one, actually. Testing a blood test. Who is to take this question? Well, just my first question, whether it's legal anywhere in the world. Well, let me answer the third question, that is blood testing is not under the purview of this examination, so it's not. There is a definition of HRT or HR procedures. So are there any places that allow sex selection anywhere in the world? Just give me the name of the countries or the places. Sorry, speakers of mic. Sorry, speakers of mic. From the places we've seen, Thailand and the US. So far there is no regulation, so it is lawful in the US. In the countries that are regulated, and New Zealand, Australia and the UK, there's prohibition, and that also includes Singapore. I ask this question because if the law applies to something that is banned all over the world, then, well, if you can't take any action in Hong Kong, then you can lodge a complaint in the person's country. This is a way to deal with matters on the internet. Okay, we can't take any action in Hong Kong and it's still illegal in your country, then we'll lodge a complaint in your country. But if it is lawful in the US, then my second question is rather crucial. There is an American person who runs a business in the US. Of course, he has to promote his business, and he does so on the internet. And Hong Kong has access of the information, and if he passes through Hong Kong, then he will be arrested under bracket 3A. Well, this is not just about committing that act. There is also the mental element, the mens rea. Yes, he runs such business. He is American. He knowingly do it. He has a business. So he disseminated the information in Hong Kong, and he passed it through Hong Kong. He wasn't planning to do anything in Hong Kong, but he can be arrested because this does not intend to catch Hong Kong people only. It's an American person. He runs a business in the US, so he does it knowingly. He published the information to the world. He passes through Hong Kong as a visitor. Not here to give a seminar or anything, but he's caught under section bracket 3A. Of course, I will complain against him. I'll report him. The reply dated the 8th of March. Please refer to the answer. The 8th of April. Well, if you can see the advertisement in Hong Kong, then it constitutes distribution in Hong Kong. But of course, there are many other conditions to be met, not just distribution. Okay, the box against distribution is ticked. And whether there is an offense, it depends on whether there is sufficient evidence showing that the act of distribution of the advertisement and whether the act of paying for the advertisement takes place in Hong Kong. So it says it takes place in Hong Kong under bracket 3A. How do you define that? A rate cause is the word. I think Mr. Leung's question is if someone can see the advertisement in Hong Kong even though the service, the target group is not Hong Kong people. According to the answer dated the 8th of April, that person can be arrested. Well, let's go back to the word of 3A. It is an offense for a person to publish or distribute knowingly such advertisement. So there are two parts. Of course, the advertisement to be distributed or published in Hong Kong and cause the advertisement to be published or distributed and in Hong Kong. So the content is uploaded onto the internet in the US, but you can see it in Hong Kong. Then the part cost is not satisfied because it has to take place in Hong Kong. So you can upload it in the US and not in Hong Kong. Let me ask the question. That means, well, I think it's rather dangerous to answer this way, because if there is a Hong Konger who causes for the advertisement to be uploaded outside Hong Kong, then it cannot be caught. So it is published or distributed. Well, if it's the American, just answer me whether that person has broken the law or not. If that person knowingly, well, if the advertisement can be distributed in Hong Kong and that person knowingly do so, that is distributed in Hong Kong. Of course, it's knowingly, because once you upload it on the internet, it's for the world to see. It's not the case that I am for you or against you. Just give me an answer. And I think when it comes to the provision, that it relates to a lot of matters related to the internet. Before the next meeting, they have to give us the information we sought and whether it can be enforced. What is the spirit behind? Your question was very valid. It's uploaded onto the internet. It's done in the US, so for him, it's perfectly legitimate. And he comes to Hong Kong as a visitor. What happens? So we want to see whether this provision is reasonable and rational and logical. I don't think your question can be answered. If you need time, you tell us that you need time to prepare for your answer. You mull over it, mull over the relevant legislations related to the internet. We've asked the DOJ to give you a summary. We will take that into account. And I'd like to add that the person knowingly does it. And knowingly focuses Hong Kong. No, it is US business. Because it is legitimate in the US. And it's perfectly normal to place advertisements. It's just that he comes to Hong Kong and I report him because I bear a grudge against him. Just now the DOJ explained that there are a number of elements, knowingly, on purpose, and whether to decide that person is culpable, it relates to the evidence. If it's related overseas, well, there may be certain difficulties. But Mr. Leung, Dr. Leung, maybe you wait for the next round. Well, an advertisement is placed under his name on the internet. I'm sure that someone will follow up. Second round, Mr. Mok. Let me ask all the questions because they may need time to follow up on some. I don't want to wait for the next time to ask the questions. Just now you said that most of the problems come from newspapers, but now the way it's drafted, it gives the impression that it targets the internet. And you've also set out that there will be enforcement difficulties. It gives the impression that you are trying to regulate the internet step by step. On one hand, you advocate innovation technology, and on the other hand, you're threatening server operators and internet operators. You talk about regulating distribution and placing advertisements on the internet. Well, I want a lot to be done. Well, that's related to the settlement system and also the copyright system. I would like to get some comparison. When it comes to the copyright ordinance, you told us that we don't need to worry. I don't know whether it's because they gave us so many reassurances because they are afraid that the bill will not be endorsed. But here you said you don't know. It's for the court to decide. You have to make clear the legislative intent.
Well, we don't know how the judges will rule on those cases. So you are not even willing to give us clear explanations here. And you haven't answered any one question raised by the legal advisor. The first question is about distribution and publishing. And your answer says that these the coverage is rather vast under these definitions, and there are certain conditions laid out. So perhaps, Chairman, after when they come back in writing, can they list out all the conditions to be met, say the mens rea and so on? So a list of such factors should be listed out. At least we can be seen as a committee discharging our duties and know exactly what you plan to do. The way it is drafted is too broad now. Second, hyperlink. Mr. Raymond Chan mentioned about the copyright ordinance at that occasion. On discussing the copyright ordinance, he said that hyperlinks are not a problem. How come that you're not towing this line when you talk about hyperlink? You said that there is no case law in Hong Kong, and the legal liabilities are not certain and so on. And the control on obscene and indecent articles ordinance, there has been a case where a person putting up a hyperlink is found guilty and in the magistrate's court. So can you be clear about whether there are case laws previously, and also tell us whether those cases still stand? And as far as I know, under that other ordinance, a person has been convicted previously. And Chairman, you said that you also mentioned about purporting. That is a relaxed term as well. And a colleague mentioned about academic seminars, and the legal advisor also raised about discussions on the internet. You, in your answer, you seem to be very arbitrary. You said, well, it may or may not constitute advertisement. Well, that has to be linked, say, to academic freedom, freedom of speech, and so on. That has to do with question 6. In other bills committees, say the copyright ordinance, copyright amendment bill, the government has been trying to reassure us that there will not be prosecution on a number of areas. But then here, you said that it will be a matter of fact and degree for the tribunal of fact. How come that this is so here? You said that there have not been any cases. Well, please present us with some cases. You said that we'll just count on the judge to make a ruling, and that shouldn't be the case. Question 7. Perhaps I would suggest that you leave some time for the administration to answer your questions first. Question 1 to 6 are specific questions raised. Anyone to take those questions? Who? About hyperlink. If you send a hyperlink or pass hyperlink, which question are you talking about? Question 2 on hyperlink. Hyperlink represents the address of a website. Whether it constitutes an advertisement, yes, to my understanding. And that has to do with that a person controls the content of the hyperlink. Well, please go back and check that in the COIAO, there was a court case where a person posted up 7 to 8 hyperlinks and he was convicted for a certain offense. And that was this case. So don't tell us anymore that there hasn't been any cases related to hyperlinks in Hong Kong. Perhaps that doesn't constitute a case law, but anyway, there was this case. Well, he doesn't have the information on hand. Well, then please go back and check. What about question 6? Mr. Lang, is your second round. Question 6, can you answer about academic seminars, online discussions, collection of evidence? Sometimes it's said that it's difficult to collect evidence. Well, but this is altogether a different matter. If you say that you have difficulties collecting evidence and you have the law that you should enforce, then, well, actually collection of evidence is altogether a different matter. Trump tried to do it as a pretext to say that my concern is invalid. Say if an American person runs a business illegally in the U.S. and he passes through Hong Kong as a tourist, and I complain against him when he's in Hong Kong and he's arrested. And you ask him whether this is an advertisement placed by you. Are you running such business? And he said yes. He chose not to remain silent. Well, then he said yes, then you've already got the evidence. So the key of my question is, well, put it simply, will this ordinance make that tourist liable under the ordinance? The key doesn't lie in whether you can collect evidence. If there is a case and you've got the evidence and someone reports it, and then the DH receives that report, and the person admits that he has placed the advertisement, and then you've got the evidence already. Well, there is a mens rea requirement in the amendment. Of course, he is running the business. He knowingly places the advertisement, publishes the advertisement. Or perhaps even that some Hong Kong persons are his customers, receiving the service in the U.S. Perhaps this is the rich guy that we talked about. Using the example from Mr. Leung, perhaps we should have to discuss with other colleagues in the DOJ. We would go back and study it further. Mr. Leung may need some more time to discuss it with his colleagues. Perhaps we should give him some time. Mr. Chung can also further discuss with the DOJ. Mr. Leung has provided a very specific example. You should answer specifically as well. You are proposing amendments to an ordinance, and there are big loopholes in law enforcement, and that may become a laughingstock. And the legislature would not allow such legislation to be, such bills to be endorsed. We will not argue with you the legislative intent, but the way it is drafted is very problematic. Third round, Mr. Raymond Chen. Mr. Leung's question is very good. The government uses the excuse of having difficulties in collecting the evidence. That's not a good enough reply. Say if an RT expert in the U.S. runs a business and he comes to Hong Kong to host a seminar on the latest RT procedures, and then someone comes up to him and asks him, well, I want to use your service. And the doctor said that, yes, I do run a business in the U.S. and some Hong Kong people fly all the way from Hong Kong to use my services. So how will you deal with those cases? Second, for the HRTO, it doesn't it seems that you haven't been arresting anyone, doing any prosecution. Can you give us a paper to confirm that? Well, in that case, it seems that you are just trying to scare people. You are not being sincere in enforcing the law. And also on the question of internet activities, you said that you will not take the initiative to enforce law. You will wait for people to make a complaint or report. And you also quoted many overseas jurisdictions banning sex selection services and such advertisements. Have you taken a look at how the situation is in those jurisdictions? Are the laws considered too draconian in those places? If you do have such information, please share that with us. Overseas jurisdictions. Mr. Chen wants information on how similar laws are enforced in overseas jurisdictions, including how the law is drafted, enforcement situation, and penalties, etc. Well, we try to come up with more information. Mr. Look, on the first part, can you repeat your first question? Since the HRTO commenced, is there not one single case of prosecution? Yes, we can supply the information later on. What about giving us a paper in writing on the composition and the method of formation of the CHRT? Can you provide us with some information in writing, the composition, the term, the tenure, how many meetings have been held, what was discussed in the meeting? Mr. Chan's concern is whether the Council can meet with the public's aspirations that the ordinance can be enforced in a balanced and effective manner. That's his concern. Yes, we can provide information in that regard. The composition of the Council that was set out in Section 4 of the ordinance, and we will give you a name list of the Council members and the meetings held and how they are enforcing the ordinance as well. Second round, Ms. Sit Ho. Thank you, Chairman. I would like to ask about the administration's reply to the legal advisor. The question 2, in the 10 questions, he said that there is a case law in Canada, and it is said that there is no presumption that a person who merely posts a hyperlink may be regarded as publishing the content of the website. And then it is also said that it is difficult to decide on certain cases. In other BILSCOMs, we have seen cases where the administration of the DOJ have different interpretations on the same case. So can the administration give us the ruling of the case law mentioned here in Canada, so we know the context of the case? Also question 5 and also question 4. The word purporting. In other bills, we have also seen wordings like purporting. In Chinese is 看起來, 看來是. Are there different versions, renditions here? And also, we said that the matter will be for a decision by the Tribunal of Fact. If you have different wordings, then it will be difficult for the judge to decide based on the wordings. For other laws, are there wordings like 看起來 instead of 看似, what are your criteria in the choice of words? For the different renditions of the Chinese terms, the same English wording is used purporting. Will misunderstanding be created? I don't think there will be any misunderstanding. Well, then if the English wording is the same, then the Chinese wordings, the same Chinese wording should be used. Well, we may use purporting to be, purported to be, and so on. If the word is inserted in different positions of the sentence, that would affect how the Chinese wordings should be drafted. So can the D of J colleague go back and try to dig up laws where such wordings have been used? For the same word purport, then there are different Chinese versions. There may be different renditions of the Chinese wordings 看起來看似.
So people can't fully grasp what you're trying to get at. Can you find me a number of provisions with different use of the word purport in different forms, and so to show us in context what it actually means? Here you see you use the Chinese term 看起來 for purporting, and sometimes you use a different term 看似 looks like or on the face of it, and it's rather confusing. Can you give us some information about the Canadian case as well? I don't have any other questions because I know that we won't be able to get any more answers. Third round, Mr. Charles Mock. Apart from answers to question 1 to 6 that I've covered, and about 7, liability of employees. It's not just about employees. From your answer, it covers people who designed the advertisements, who helped in creating the advertisements, writing the application, design the banner. You did not say clearly whether that person is liable. You still said that it depends on what the act is. That shouldn't be your answer. You have to make it clear that if this is done, then this will happen. If that is not done, then this will happen. You can't say. You have to make it clear whether that person is liable if he's responsible for designing the advertisement. Well, you said that it's down to the mens rea. I'm glad that you did not include the word dishonesty. And the scope of mens rea can be rather wide. And of course, if that person denies liability, of course he'll say that there is no mens rea, but that person has received payment for working on the advertisement, for designing it. What about the person who worked on the program on the website? And that person would not know whether he has contravened the law, because probably all he knows was that as long as it's nothing to do with cigarettes advertisements, it's all right. For one ordinance, you provide a safe harbor. For the other one, you hum and haw saying that there is no need for a defense provision. You have to make it very clear to set out what causes a person to be liable. This will not affect your ability to enforce the law. So far, there has not been any arrests made. And I'm sure that you don't mean to catch people who write the program for websites. What's the reason for not making it clear who will not be affected, or even provide a defense provision? And that's related to question 7. Question 10. Well, I actually would like to follow up for the legal advisor. You have not answered the question. The question was about the effectiveness of law enforcement. You just gave a table setting out the number of countries, whether there is any law to regulate this, and whether there is any prohibition on advertisement. You have not answered about effectiveness of law enforcement. Is it the case that you failed to obtain the information? So answer 10 has not been answered. And I don't know whether the legal advisor will ask follow-up questions or to follow up on these unanswered questions. Well, the legal advisor and us are in the same position. We've just received the answers yesterday. Perhaps we should have some time to go over the answers for us to follow up on the missing parts. I see that the whole bill is fraught with flaws. Say, for example, those related to the internet, some very vague legal principles, and the word purport. Well, you see in the table some existing legislation. We can't cover the world, and if we will see if we can find the information related to law enforcement. Question 7 and question 10. Defense and other people providing services or companies. In general, there won't be any defense provision unless there are special circumstances. If, say, employees or a certain class of individual are not held liable, then people will try to put themselves in the capacity of these classes or the employees. It will backfire. The focus is not the capacity of the person, but the act. If an act is done that contravenes what's set out in the provision, then that person will be liable. Mr. Wong, I don't think your question has been answered. Well, you point out your question and you wait for an answer later. We'll try to get one. From what I've heard, Mr. Chung will go over the bill with the DOJ again. We still have the third round. Perhaps you listen to Ms. Ho first. Sorry. When we're dealing with the main legislation, the principal legislation, it was over a decade ago. We know that this is more to regulate behavior than law enforcement, especially when it comes to surrogacy arrangements, because you know that in Hong Kong, unless you pay, no one will be a surrogate mother, because it's no easy task to be pregnant. It also regulates Overseas Act. And I mentioned about the case that took place overseas, and so far there has not been any investigation because it's legal in that overseas countries. So no one will provide the information to support your investigation unless that person, unless the overseas party wants to blackmail that person. So I remember very clearly that there is such regulation when it comes to surrogacy arrangements. And what about sex selection service? If it's done overseas and it's been made known in Hong Kong, is it against the law? Mr. Chung? We did not add the word outside Hong Kong. So if the parents have it done overseas. So when it comes to sex selection, this is not covered. No. If it's not against the law overseas, it can be done in some countries, then why would you put in place a provision to prohibit advertisements on the internet? I will have doubts when it comes to law enforcement. If it's allowed overseas and you allow it to be done overseas, then why do you want to prohibit advertisements in Hong Kong? Why this amendment? And I think Ms. Ho has pointed it out. The act itself is not against the law overseas. Say, for example, if it's done in Thailand or the US, it's not illegal to have a sex selection service. But if you place an advertisement, then it is against the law. What is the legislative intent? The act itself is not regulated, is not against the law. But how come you regulate the placing of an advertisement? And if there is precedent that the prosecution is initiated related to the internet, then we will be very worried. If you regulate advertisement saying that, well, the service is available overseas to provide surrogacy arrangements, we can understand, because surrogacy arrangement is banned overseas as well. But if it's just about unlicensed sex selection, or when it's done not on medical grounds, so it is selective. If you want to enforce the law, then you should regulate these medical centers or people providing the treatment to stop them from doing it. And that would be sufficient to enforce the law. But if the advertisement is about a service provided overseas and you want to ban it, and you're banning something that is legal overseas, that's meaningless. I hope I've made myself clear. You have. Let me ask a question. As you know that for marijuana, in some places it's not against the law. If someone promotes the taking of drugs, of course there will be prosecution. But what about consuming marijuana? Is lawful in the Netherlands. So what if someone promotes the use, the consumption of marijuana? Yes, it's a very good example. The Hong Kong customs, you make it very clear that bringing in such a substance is against the law. And in Hong Kong, a lot of travel guides recommend it, talk about it in Chinese, in English, yes, in Lonely Planet guides as well. And in Holland, in cafes, you can try marijuana. And I think it purports to ask me to try it out. So that means you will have to arrest the publishers, the bookshops, and everyone. Mr. Zhong, let me try to explain about the amendment as well. There is already an existing regulation of the provision of this procedure. So there is regulated by way of a licensing regime. We regulate the treatment centers and medical institutions providing the service. And this amendment is also based on the same spirit, but we would like to enhance the regulation by prohibiting advertisements, encouraging people to take the service, and very often the services are provided overseas. So it's actually based on an existing ordinance. We would like to enhance the regulation. In Hong Kong, this procedure, if done not on medical grounds, is against the law. So we just aim at enhancing regulation. So there is no conflict whether it's overseas or not. The regulation under the existing regime is on the licensees. And this time, the people involved may not be in medical centers. They may simply be people dealing with the advertisement or even an intermediary. We try to use the law to enhance regulation. That's exactly my point. You either add the regulation of sex selection service to apply to services received overseas or offered overseas. You do it as a whole. You give the whole package, then we can see your logic. Just like a surrogacy, but when it comes to sex selection, it can be done overseas without breaking the law, but you ban the advertisement. You are actually targeting the media and not the service provider itself.
本地賣廣告。
Well, you can add in a provision prohibiting local advertisements. Well, because you are talking about prohibition of such services except on medical grounds, so it's like the case of advertisements placed by doctors, and you can regulate local activities. But if you don't go down that route, you don't amend the ordinance to prohibit such services provided overseas, and you're just prohibiting the advertisements, then that is very problematic. Mr. Chen. If the act itself is illegal, then you don't have to specifically provide or amend the legislation prohibiting the advertisement of such activities. I would like to talk about the definition of advertisements. I am in the media, and it's difficult to come up with a definition of advertisements. There are, features in newspapers. There may be supplements placed, and then unless it says categorically that it is a supplement sponsored by the advertiser, it's difficult to tell whether a supplement is an advertisement or not. If newspapers carry feature stories with detailed information on each RT procedure cases, so after the ordinance or the bill is enacted, will such features come under the scope of the ordinance? Any response? The drafting and the coverage of the amendment bill are very problematic. There are a lot of ambiguities in areas like the internet activities, the word purporting, and how the law should be enforced. You would not enforce the law against the parents who choose the sex selection services, but then you are banning the advertisements. So there is a conflict there. You drafted it in a very strict way, but you don't seem to be very sincere in enforcing the law. The scope is too broad. You said purporting. And the legal advisor has raised a good question. And so far you haven't given a very good reply on what you meant by purporting. So we are very worried. We are worried that this ordinance will have implications on other ordinances as well, as far as internet activities are concerned. Internet websites, books, magazines, newspapers, etc. may be covered in the future. We don't want to accept at this stage the amendment bill in the way it is drafted. Members have already raised this. We should have a public hearing, and we should allow some time for the administration to go back and study the issues you raised. we raised questions about the CHRT and the framework for enforcing the law on the Internet, and also the application scope of the word purporting. We also want to take this opportunity to give bodies concerned to give us a response. We will first set the date for a public hearing and invite the relevant bodies to give us their views, and then after the public hearing, we can come back and discuss all the questions that we have raised. If there is no further question, then the clerk has given us a date, 27th of April, on Monday, 2:30 to 4:30. That may clash with the meeting of the environmental panel. Well, so many meetings are ongoing, and it's difficult to avoid a clash of schedule. If you don't have any objection, then I would suggest that 27th of April, 2:30 to 4:30 p.m. at meeting room 1, we will hear views from deputations, and in the meantime, we will ask the administration to get prepared. And then we would also ask colleagues to give us names of bodies to invite to the public hearing. Does the administration have a timetable on the bill? Is it the case that we can take it forward gradually? Yes, I don't see any urgency in this. All right, so much for this meeting today. Thank you very much. The next meeting, 2:30 p.m., 27th of April, we'll listen to views of deputations.